decision. I mean, from my experience, 9 out of 10 judges like prosecutors more.
Well, they should, especially federal prosecutors, Vinnie. And the feds are finally flexing their muscles after years of being dormant under the previous administration, Bill Barr and Jeff Sessions. So I love what our new attorney general is doing. These motions are really important, though, because the defense in this case is self-defense. And to the extent that, the McMichaels and Bryan can dirty up Ahmaud Arbery and bring in his prior criminal history, the fact that he was on probation, and they're really doing it both in terms of self-defense and how he's acted with prior contacts with law enforcement, but also Georgia's previous citizens arrest law that's been now repealed. That's going to be relevant in this case, and that's why all of this conduct, at least from the point of the defense, is highly relevant and going to be key evidence in the case if the judge were to allow it in.
If the judge allows it in. He seems to be pleading delusional insanity, mental illness for the victim. I've never seen this before. What's going on? And do you see it being relevant, or do you even understand where he's going with this?
I understand where he's going, Vinny. It's creative. It is not relevant. No judge is going to allow this. These are collateral issues. Even these prior instances, you're really opening the door to all sorts of witnesses and law enforcement to come in to testify. There's really only one instance where I've seen this type of evidence come in, and only one instance. That is in a self-defense case where the defendant takes the stand, where the victim takes the stand. If the victim takes the stand and says he or she is peaceful, then you can cross-examine them on these collateral acts. That's the only time. Well, in this case, Ahmaud Arbery, the victim, is not going to take the stand. He's deceased, so none of this evidence is going to come in.
Derek Chauvin was a police officer. These three guys, not police officers, okay? But it's going to be three defendants all at once, three sets of defense attorneys and defense teams versus the prosecution. Who has an advantage here? Does the advantage go to the defense because they have more numbers, or is that a disadvantage because they're all there?
The advantage usually is for the prosecution when you tie in multiple defendants in a case. Usually the defense attorneys want to sever. In this particular case, you have one who is the least sort of culpable, which is Roddy, and obviously Travis, the one pulling the trigger and allegedly making the racial slur, he's going to be the most culpable. So it's going to be interesting to see how his father plays the case, because that's an interesting relationship between him and his son. If his attorney is going to throw his son under the bus. But if I'm the state here and if I'm the feds, I want to try all three of these together, especially Roddy Bryan, because that case is going to be the most challenging.
Then the judge has to decide, okay, what does he actually get? What does the law tell me he should get? And there's a reaction to all of that. How do you think all of this plays out in this case? I mean, this is not easy. There's a lot of discretion. You go from 12 and a half presumptive up to 40 years, and there's so much space in between. In many cases, judges don't have that much space.
I agree. As a prosecutor, you don't want to overreach. You ask for the max, the judge may react the other way. Same thing on the defense side. If you come in too low, that can enrage the judge. But let's not forget.
How about the public? How about enraging the public? Does any of this enrage the public? Whether something is asked for that's too much, too little, or is given too much, too little?
Even though it shouldn't, it will absolutely affect the judge's decision. And there's no question, judges are people. I mean, they're subject to public perception. In different states, they're subject to recall or election. So the Judge Cahill will focus on, even though he shouldn't, that has to be in the back of his mind when he's sentencing Chauvin. But let's not forget, Chauvin didn't testify. He didn't go up there and perjure himself. He didn't obstruct justice. He was willing to take a deal. It was a low-end deal, a 10-year deal. So that's something that I would emphasize too if I were Chauvin's defense attorney, Eric Nelson, and just say, listen, Your Honor, we're also facing federal charges both for this case and the 2017 case. That time may run consecutive as well. So there's a lot of creative arguments that Chauvin's attorney can and will make. But I agree with Dave and Theresa. I think anything less than 25 years here is a miscarriage of justice and would be absolutely inappropriate given the facts and circumstances of this case. Let's not forget, this wasn't just an accidental shooting. This is someone who intentionally, even though it wasn't charged as such as first-degree murder, this is someone who intentionally killed George Floyd, in my opinion.
In your opinion, because prosecutors stayed away from that intent as much as they could during the trial. The two rookies, right? One of whom, Chauvin was his training officer, 4 days on the job on their own, and the officer who is doing crowd control, all three of them should have intervened. Do you think that's a winning argument in front of a jury? You think you'll convince 12 people that for not intervening, the two rookies and the guy doing crowd control, that they should be facing 40 years in prison as well?
Vinnie, I'm going to answer it by pointing to what the feds did. And in the federal indictment, interestingly, only King and Tao were charged with failing to intervene. Lane was not. A lot of people aren't talking about that, and I believe that that is based on Lane's statements to Chauvin. Should we turn him over? Should we relieve the pressure? So in the federal indictment, Lane is only charged with failing to provide medical attention as the factual basis there. So I think this is something that the feds have caught on, and you have pointed out as well. I think Lane is going to have the strongest argument for not intervening in this case, because he did try to intervene with the statements that he made, allegedly. That's going to be his defense here. Heinous crime, right? He stabbed her a horrific number of times. And let's not forget, when he's being arrested, he takes a selfie in the back of the police car with a peace sign that says, "Does anyone know where Tristan is?" I mean, it's just, like, my heart breaks for this family. And each state is different. Obviously, we have experts in Florida. I can tell you here in California, actually, there's a proposition on the ballot in 2018 that said juveniles aged 14 and 15 can no longer be prosecuted as adults. And that went all the way up to the California Supreme Court just in February of this year. It was challenged and it was upheld. So at least here in California, the legislature and the public, they've decided that 14 and 15-year-olds can't be prosecuted as adults. I understand the arguments on both sides. Believe me, I'm a gung-ho prosecutor. I have a daughter of my own. I can't imagine how I would react. But to put someone who's 14 years old in prison for the rest of his life, or even 25 years or whatever number of years, that probably, in my opinion, isn't just either. I'm a big believer in cameras in the courtroom. Justice Roberts, you heard me. In the George Floyd Justice and Policing Act, I think law enforcement should have body cams. Their vehicles should have cams. Let's not forget, I don't think George Floyd, that case would be prosecuted or would be prosecuted as a second-degree murder if we didn't have those cameras. I mean, that's key evidence in the case, and it holds officers accountable, and it restores public trust. So, I agree with Theresa. I just don't think that she was obstructing in this particular case. She's asking the officers questions. They're getting upset because she's recording with audio. And I think a lot has changed since 2009. And I think the public perception has shifted. And hopefully more states do mandate it. And if they don't mandate it, they do allow audio and video recording of police officers. So let's talk about what's happening in Florida right now. You have a sheriff's deputy, Wester, who is on trial for planting drugs on hundreds of people, and he happened to be caught by his own body cam. So this holds officers accountable. This is very important.